Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There are approximately 108 days remaining until voir dire, which is the process of jury selection in Idaho versus Kohberger. 108 days to perform a number of tasks that the parties need to perform in order to prepare this matter not only for voir dire but for the case in chief, where Mr. Kohberger, who remains innocent under the eyes of the law of all charges that have been brought against him by indictment, until or unless one of two things happens. Either he pleads guilty or he is adjudicated guilty by that future jury. Voir dire is set by operation of the redacted order governing further criminal proceedings and notice of trial setting that was entered on October 9th, 2024. This trial and pretrial order was rendered shortly after the matter of Idaho versus Kohberger was transferred, venue changed from Latah to Ada County. So what else has yet to be done in order to prepare for voir dire and for the case in chief, which will occur according to this order on August 11th, 2025. If we look at this order, which you can obtain by going to the Idaho cases of interest, plug it into your search engine of choice, it will bring you to a website maintained by the Idaho Supreme Court that will list various cases for you. One of them is Idaho versus Kohberger. If you go to that portion of this website and hit the link for Idaho versus Kohberger, you will see all of the documents that have been filed publicly in the case since December 29th, 2022, which was the inception of the case. That's when the affidavit of probable cause was filed. It's when the criminal complaint based on that affidavit of probable cause was filed. It is when Judge Megan E. Marshall, who was the magistrate in the matter, found probable cause, entered an order of probable cause, and entered the arrest warrant, which authorized law enforcement to apprehend Mr. Kohberger, take him under arrest, which is what occurred one day later on December 30th, 2022. You can review the documents from Commonwealth of Pennsylvania versus Kohberger, which are available for you to review online to learn what happened during the arrest, the warrants, the Pennsylvania affidavit of probable cause, and other related documents. Getting back to the October 9th, 2024 redacted order governing further criminal proceedings and notice of trial setting, we see immediately on page 1, Section A, voir dire and trial setting, jury questionnaires. This is the only portion of the entire order that is redacted, will be administered approximately, and that date is redacted in 2025. We're going to talk a little bit more about the jury questionnaires in just a moment. Voir dire, as we have said, shall commence July 30th, 2025 at 9 a.m. And then, after that jury is selected, there must be a panel of 12 citizens who will serve on the jury. The jury trial shall commence on August 11th, 2025. This is the case in chief. This is when the prosecution must prove beyond a reasonable doubt that Mr. Kohberger is guilty of the 5 felonies that he was charged with by indictment and that he will stand trial on. Mr. Kohberger is, under the eyes of the law, considered innocent of all charges until or unless one of 2 things occur. He either pleads guilty to these charges or is adjudicated guilty by this future jury at the jury trial. There's a paragraph here that provides you with further details regarding the jury trial. Next, a final pretrial conference will be held on May 15th, 2025 at 9 a.m. and continue on to May 16th, the next day, if necessary. Earlier status conferences may be requested of the court and or initiated by the court. This last sentence, there had been no other pretrial conferences that had been requested by any of the parties, at least as of right now, and we are right now in mid-April, a month away from the pretrial conference, nor has the court of its own volition set another pretrial conference. But what occurred during the in limine hearings this past week is that it was stated that Mr. Kohberger's offer of proof as to any alternative perpetrators will occur by virtue of hearing either at the time of this pretrial conference or around the time of the pretrial conference. As of right now, this has not yet been set. We are looking for some sort of a hearing notice and other information to hit the docket regarding this matter. What is a final pretrial conference? This is when the parties get together before the court, discuss where matters stand, discuss if anything else needs to be entertained by the judge to ready the matter for trial. For example, is there any discovery that's still outstanding? Is there a motion to compel that needs to be entertained? There is one that was filed back in March. It is the 7th motion to compel discovery, where Mr. Kohberger asked for an hour-long hearing. This had to do with his 22nd supplemental request for discovery. That matter remains pending, and it has not been withdrawn by the defense. So we're not sure what's going on with that 7th motion to compel discovery. We go to the next page. You're going to see that under Section B, all of these matters have been entertained with the exception of the motions in limine. The only thing that's left to occur regarding the motions in limine are Judge Hippler's written orders on them. Next section, discovery and expert disclosures. Most of these matters have already occurred. The list of experts, what the court did at the bottom of page 2 going into page 3 was set a deadline for disclosure of experts for both the guilt, which is known as the case in chief phase, and also the penalty phase, if any. If the state of Idaho is successful in persuading that future jury at trial regarding Mr. Kohberger's guilt, matters then go into the penalty phase. It will be the equivalent of a second trial to determine sentencing. And this is where the experts in the penalty phase come into play, if any. Everything here, the deadlines have all passed with the exception of the rebuttal penalty phase experts. Those are due April 28th, 2025, and that's where the state comes back to rebut the defendant's penalty phase experts with any additional experts that the state feels it needs to bring forward. They need to disclose them by April 28th, 2025. That is the deadline. Trial materials, some of these things have happened, some are yet to happen. The proposed jury questionnaires that were addressed on page 1 shall be simultaneously filed under seal by March 24th with objections March 31st. Both of these events happened. The proposed jury questionnaires were the questions that either side, the state and the defense, wanted to be included on the final product, the item that will be disseminated, that will be administered to the citizens of Ada County who are selected for possible jury duty in this case. The court administration will then disseminate and will administer the jury questionnaires for the potential jurors to fill out, and then that tool will be used at voir dire to help in the selection process. The objections were any objections that the state had to the defense's proposed jury questionnaires and that the defense had to the state's proposed jury questionnaires. A closed sealed hearing is the next event that's coming up in the case on jury questionnaires proposed will be held on April 16th, 2025. This is a sealed and closed hearing, meaning the public will not be able to either watch the proceedings live or watch them as they are telecast, because they will not be telecast. Proposed jury instructions and trial briefs, these are coming up due this week on April 14th. Any objections or stipulations, that means agreements to what the proposed jury instructions say, are due by April 21st, 2025. The proposed exhibit list, these are the documents that will be used or intended to be used during trial, shall be filed and exchanged by April 21st. The parties must identify the exhibits specifically and individually, with each exhibit referenced by the Bates number. That's the number that you've seen in some of the documents. It's at the bottom, usually in the middle of the page, that identifies the document, so that if it's being called up, they could say, and Judge, we are now would like the witness's attention directed toward Bates stamp number 1001. It would be at the bottom of the page. Then we see copies of the actual exhibits themselves shall be exchanged also on April 21st. And we have indications here as to how they're to be marked. S1 refers to the state, D1 are the defenses, and they have the defense will use blue stickers beginning with D1, the state using red exhibits to distinguish them from each other. And then the witness list for the guilt phase. These are the people that are not experts that either side intend to call. These are people with actual knowledge, that have seen things, that have heard things, that know things. An expert is someone through specialized skill, training, and experience are brought into a case by either of the parties. The guilt phase lay witnesses, these are people, again, with actual knowledge of events that are relevant to the case. These lists shall be filed under seal by April 21st. Penalty phase, if any, lay witnesses shall be filed under seal by May 5th, 2025. And the list of witnesses must be identified per this order with specificity individually. So the parties have to, with specificity, list each and every witness that the state intends to call during the case in chief, that the defense, if the defense is going to put on a defense, the defense is not required to do anything of the sort, but if the defense willingly decides that it will or may call witnesses in their defense's portion of the trial, they must now identify who those guilt phase lay witnesses are. The witness list shall be filed under seal by April 21st, 2025, so that the public will not know who the lay witnesses are for either side. Penalty phase, same thing, filed under seal by May 5th, 2025. And here, when the court is saying here that must be individualized with specificity, not merely identified by groups of people. And then we see that this takes us to the end of the pre-trial and trial order. So we're learning now that the remainder of April is going to be a very busy month for both sides as they continue to prepare for voir dire, which will happen in 108 days. If you have any questions, any comments, please leave them here. This is Kathy. Thank you for joining us here today.